Good evening. It's probably 5:35, let's say, Wednesday, June 28th. It's the monthly meeting of the Urbana Human Relations Commission. Could we please have a roll call?
Frances Ripberg Baker. Here. Carol Bradford.
Here.
Stacy Burnett. Lisa Mosley.
Here.
Daniel Larson.
Here.
Peter Resnick.
Here remotely.
Samuel Bynum. Catalina Thomas.
Here.
Cecilia Clark.
Here.
Preston James.
Here.
Todd Rent.
Here. Alrighty, thank you. Looking over tonight's agenda, are there any additions, edits, or corrections that need to be made? If not, is there a motion to approve?
I move that we approve.
Second.
All those in favor, please say aye.
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 Opposed, the same? Thank you. Looking over the minutes from our May 10th meeting, are there any additions, edits, or corrections that need to be made? If not, is there a motion to approve?
Move approval.
Second.
Any discussion? Okay. All those in favor, please say aye.
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 All those opposed, the same? Alrighty, we can,
Well, for public participation,
Oh, yeah.
can Todd Rent, and you guys may all recognize Todd
Yes.
from years gone by, but he is back with the city as our Human Resources Director / everything else over in HRO. So he wants to kind of give you guys a lay of the land in terms of the future and where we're attempting to go.
Thank you, Ms. Clark.
Mhm.
So, hello, everyone. For those of you who I have not who are not familiar with me, my name is Todd Rent, and as Ms. Clark said, I've rejoined the city as the Human Resources Director. I've also been asked to provide some administrative oversight to the Human Relations Office, just based upon the fact that I did it for 8 or 9 years. And we're going through a period of transition, and I just kind of wanted to let you know exactly how we would be handling the functions of the office during the period of transition. First of all, I need to announce that Alex Batista obviously is no longer with us. He has actually accepted a position with the Illinois Department of Human Rights, which I think is going to be great. Alex made outstanding contributions to the city in regards to community outreach, and I am very excited about the position that he has, and I'm sure that you guys will be coming into contact with him in various forms. And I think everybody should be really happy and proud of where he is. So, in terms of the city of Urbana, what we have decided to do, first of all, I think that it is important to continue down the trajectory and continue with the momentum of the community outreach that Alex was doing. And I think that with our team, we have obviously Preston James and Cecilia Clark and Monique James. I think with that team, we're going to be able to continue at the same level of community outreach. Maybe without the level of charisma, but certainly we're going to be able to. Preston and Ms. James and Ms. Clark have a good amount of charisma. I'm just not sure anyone has Alex's charisma.
Right. He's unique.
Definitely different. But I think that we're going to be able to move forward with many of the community outreach initiatives. But I also think that there's going to be a refocusing in on enforcement of the human rights ordinance, and more specifically, meeting the time requirements of the human rights ordinance. I've had the opportunity to have a couple of meetings with the mayor, and I think she is very committed to ensuring that we are meeting, to the extent possible, those time requirements and really vigorously enforcing the ordinance just to ensure that the ordinance is able to accomplish really what it's supposed to be doing, which is to make sure that there's a level playing field here in private employment in the city of Urbana. And so to that end, what we're going to be doing, we're doing a couple of things. We've asked Ms. Clark to remain on in her capacity. I'm not sure how widely it's known. She is here in a part-time capacity as an emeritus and providing incredible guidance and expertise in the area of specifically of the Human Rights Ordinance. And she's going to be the main point of contact with you as the Human Relations Commission. I've also spoken with Preston about providing investigations, doing primary investigations. So as many of you know, Preston is a former police officer at the city of Urbana. He's trained to conduct interviews, and I think it will be a good utilization of a good leveraging of his skills to really have him perform what I would call the footwork or the legwork of the investigations. So going out, basically collecting in the documents that we would normally do, and then going out and conducting interviews with the respondents in conjunction and in consultation with Ms. Clark to make sure that we're hitting on all of the legal requirements. And then once we have that investigation completed, then Ms. Clark and myself will be reviewing the initial determination to ensure that it covers all of our legal bases. But I'm kind of excited because I think that we have the people on the team and we have the ability to deploy them in their areas of expertise that I think is going to go a long way towards helping us to enforce the ordinance in terms of the quality of enforcement, but also in terms of getting things done in a timely manner. I can tell you, and I had this conversation earlier today, I think with the ordinance, everyone who's ever touched it has wanted to ensure that we are able to provide fair and impartial adjudication of these cases, but also where we see that there has been some type of discrimination, to try and correct the imbalances and quite honestly, the damages and injury that result from that discrimination. I think that this is another model that we've not had the opportunity to try because quite frankly, we haven't really had the staffing to try it. And now we have the staffing, and I'm really excited about the prospect of moving forward. Now, where this will impact you, if you remember, previously we had a listing of our cases, and that listing of cases provided the days from the date that we had received the response from the respondent. And that was kind of a way of keeping us on task. And if we were getting, if the days were beginning to get very high in number, you would often come to us and say, okay, exactly what's going on. And the response typically would be, well, we're in the middle of settlement negotiations. We're reaching out to the respondent and the complainant, trying to find a way to adjust the matter before it actually goes to its initial determination. I think that that was a healthy oversight mechanism, and I'm recommending that we restart that now so that you all can see exactly how long it's taking to settle these. And I think it's important as a matter of oversight, but I also think it's important as a matter of helping everyone to have a clear understanding of exactly how long it does typically take to deal with one of these cases, so that if there are issues in terms of reviewing the ordinance and determining whether or not the current standards that are laid out in the ordinance are realistic, you have an ongoing record showing you the trend lines of how long it's taking. And so I'm asking that we reinstitute that. And also, when you see that, I want to let you know, you are going to be seeing some cases that are fairly old. They've been around for a while, for a number of different reasons. And the one thing I've always advised people is, this job, the job of trying to enforce the ordinance while at the same time where you see a wrong or where you think that there's a wrong, ensure that you're not just conducting a surface level investigation, but you're really digging in, and if there is discrimination, you're giving it every shot to prove that, or at least to establish that if it's in the record. You know, sometimes that can be a very complex process. And so what you will find next month when we actually generate this report is that some cases are going to be fairly long, right? I will tell you, we are doing our level best to resolve those cases. It is very likely, however, that some of those cases will come to you for adjudication. And so I just want to be flat out with you, prepare you for that, to say, I think that you all are going to be putting in some work on some of these cases in terms of adjudicating them, because we are going to be moving them towards public hearing. Either we're going to be settling them or moving them towards public hearing, most likely in the next 60 days. Yes, sir.
About the time you transitioned last time, we had put in place that mechanism where we were going to try the adjudication a little differently. Are we still looking for cases that might fit that mold, or are we
Yes.
moving away from that model, or what are your thoughts?
I think I would leave that up to your discretion, but I would highly recommend it, particularly for these cases, for a number of different reasons. But I'll leave that unstated. But yes, I
And
would
Daniel
highly
was referring
recommend
to a hearing
it.
officer.
Yes, yes.
Yeah,
I
I'm
should
sorry.
say that. I'm sorry, yes.
I'm
He was
sorry.
referring to the hearing
I'm sorry,
officer
guys.
model. I would strongly recommend that you go forward with that. Because it's been so long since you've passed that rule, you know, it would certainly be within your discretion to reevaluate whether or not that's what you want to do. It would be my recommendation, looking at these cases, they have a bit of complexity and some other factors. Bringing someone in who is a trained adjudicator to keep things on track, and also to very clearly explain sort of the legal requirements that are attendant to the various proofs that you're going to see in the cases, I think would be very helpful. But that would be my recommendation.
That's a good recommendation.
Any other questions? I don't want to be before you long.
Just a quick one, Todd.
Sure, yeah.
Is there a long-term plan at this point, or is the long-term sort of whenever the mayor finally gets settled in and is no longer running around like a whirling dervish?
Yeah, she's putting in a lot of hours. I'm just gonna. I'm not sure I'm allowed to say that. But I'm just gonna say that. And we're kind of trying to dig out at this point, and I'm not referring to her in terms of HRO, in terms of getting on top of the cases that we have. I think we're going to be able to do a better evaluation in terms of what we're going to do going forward on a permanent basis a little bit further in the future. I know that we probably can't hold on to Ms. Clark forever, but gee, we appreciate having her here right now. So, and getting Mr. James trained up and developed to do the primary investigation, I think is going to really set us up for sort of this long-term future structure that we will have, whatever it will be.
Thank you, Todd.
All right, thank you so much
Thank
for your
you.
time.
Nice meeting you.
I'm going to run out so that if I stay, I'm probably going to talk too much and keep you here until 7. So.
And if you run into Don on the
Yes,
way, just-
I will. I will send him
Okay,
right up.
Thank you. Thanks,
Take
Todd.
care.
Good
All
to see
right.
you, Todd.
Sir,
Welcome back.
back.
thank you so much.
Yes, if she doesn't mind me saying so, tomorrow is going to be Vasilia's last day
Yes.
as emeritus, and so we are
Oh my
incredibly
goodness.
grateful that she's agreed to stay on and help us during this important transitional time. So thank you.
Thank you. Thank
Thank
you.
you very much.
Here, here.
All right, so any other public participation? Seeing none, hearing none. We have no old or new business, so I think we can jump to the staff report. Vasilia, I turn it over to you.
Okay, everybody has the EEO workforce stat.
Yep.
Okay, have you had a chance to look over it? Any questions or concerns about staff recommendations on it?
I can't make heads or tails of the Sherwin-Williams numbers.
Yeah, I think they submitted it 3 times, so. And I think they gave you corporate numbers, right?
Yes, they gave us corporate numbers. We called trying, first and foremost, we didn't have legible numbers at all. So we finally got corporate numbers. What I do know, the Sherwin-Williams business that's here in the city of Urbana is very small. It is very, very small. Yeah, the one here. I'm almost positive that they're probably going to meet our requirements of 15 or people under. That's how small it is. So when I gave you the corporate numbers, I knew I would probably have to explain that to you, which is why we did recommend 2 years, because it's a very, very small organization here in the city of Urbana.
Kind of what I figured. Thank you.
Due to numbers, should we break up new applications and renewals for approval? Is that just,
Yeah.
does that make sense? So it looks like we have 6 renewals. Lucidity, I'm not sure if I'm saying that, Lucity.
Those are new.
Sam Pax 5-star Ford, Roland Machinery Company, Sherwin-Williams, which we were just talking about, Todd Shoemaker, and U.S. Equipment Sales and Rentals. We see the staff recommendations. Is there a motion to approve to discuss, or?
I
Or any-
move that we approve to discuss
Okay,
these.
so it'd be
new
Lucid,
applications.
Lucity for 1 year, I should put that on record, Sam Pax 5-star Ford for 2, Roland Machinery for 1, Sherwin-Williams for 2, Todd Shoemaker for 2, and U.S. Equipment Sales and Rentals for 2. So we have a motion on the floor for that. Is there a second?
I'll second.
Okay, discussion. Questions, comments, observations? Peter, anything?
Lucity looks terrible.
Yeah,
Yeah.
you think it's 6 months,
Pretty
or?
good for women.
Mhm.
Yeah, I mean, and Roland, I didn't look to see where Lucity and Roland are located.
I can't.
Just a second. When you cast that.
Lucity is in Overland Park, Kansas. And Roland Machinery is in Springfield, Illinois.
Oh, Oberlin has a population of just under 1,800.
So small town.
Oh,
They have a lot of women.
They do have 43% of their working force is women, which is laudable.
Most,
For sure. And then just unfortunately,
no.
No minorities.
one
No
Latin.
minorities, no person. And no Native Americans, which
Out in Kansas, possibly.
they might.
Yeah, that Overland Park is actually close to Kansas City
Oh, wow.
and Kansas
Okay.
City, Kansas.
Okay. So it's like a
So
suburb.
it is a suburb of
Ah.
Kansas City.
Okay.
Is it lighting? I forgot.
Is it what?
Is it a lighting company?
That's what I'm looking at right
I'm
now,
sorry,
trying
thank
to
you.
find out what it is.
I can't remember.
That makes sense.
Sounds like.
Yeah, looking at the 2010 census data, Overland Park itself is very white. Obviously, Kansas City is not. But we've got 84.4% white, 4.3% of African American, 0.3% American Indian, 6.3% Asian, 2.1% other races, 2.5% two or more, 6.3% Hispanic Latino.
Thanks,
If that
Peter.
helps. I don't know that it does.
Can you look up that company to see what it's
Oh, I didn't, that's okay. It's no,
Oh, it is.
Okay.
You can, it matters.
not-
thank you, thank you.
Yeah, I think it matters.
And I think in this particular case, the question is, you know, 6 months is worth it if we think it's going to be an ongoing relationship and there's something they can do about it in 6 months.
Public Works.
Yes.
They have 2 job openings.
So you better get on it.
So is it a one-time?
So what I gathered, which is why we have so many today, Public Works is they're bidding out contracts for different things right now for some different parts and things that they're using for the city of Urbana. I don't know if it is a one-time thing, but I'm leaning towards it is, because I got an email with roughly, out of all of the ones that we have, 5 of them Public Works supervisor sent through, trying to get them approved so that they could at least get the bids in before this fiscal year to get some things done. So again, I don't know if it's somebody that we're going to use. More or less, they're trying to get bids in, and if they can beat the different bids, they'll go with them. But
It looks like
Would-
it's a
It's
software
management
company
support.
Software.
Software.
for Public Works.
Yeah.
I'm more concerned about Roland and Springfield, Illinois than I am
Hey,
Lucity
come on
in Little Overland Park, Kansas.
in. Did you have a hard time locating it?
Right, it's a very small population.
Peter, what
I would
Stacy
tend to
said
agree
is
with
she's more concerned about Roland Machinery being in Springfield and their numbers being not as diverse as they could be than she is with Lucity and Overland Park.
Yeah, I think she's exactly right.
Would we support if we changed, are you thinking about 6 months maybe, Carol?
I would go with 6 months just because I know that
It's very diverse.
there's a lot of diversity in Springfield, especially a huge African American population. They're less than a half hour from Decatur, Illinois, which is also very diverse and high unemployment rate, and those people go over to Springfield to look for work.
Okay, Peoria's no, Peoria.
Did you hear her response?
Yeah, absolutely. No, I can hear reasonably well.
Okay.
Just a possible, maybe with Lucidity, if we do approve them for 1 year, we just put a line in our letter saying we were, I don't know, troubled or, it caught our attention that your numbers are a little troubling or something.
I can send them the same letter that I send the 6-month people saying I need you to give us some good faith information to show that you are actively seeking minorities in your business.
I think that would be sufficient.
So we want to give them a year, but still go ahead and send the correspondence through.
That we did,
Okay.
that'd be great. Any other comments or questions? I'll slightly just reiterate, so now we're Lucidity for 1 year with the slight stipulation, Sam Pax 5-star forward for 2 years, Roland Machinery for 6 months
With the letter.
with letter as well. Yep. Sherwin-Williams for 2, Todd Shoemaker for 2, and U.S. Equipment Sales and Rentals for 2. So that's a slightly updated. Do we need to re-motion, Peter, or is that a?
Someone can offer a friendly amendment,
Oh,
and
yeah.
the
To be fair,
person who made the motion and the second can accept that friendly amendment.
Carol, could you make that friendly amendment, please?
I move for us to make an amendment to our original number of years we
Yeah.
were gonna do.
For all new applications, yep.
Do I need to read them off?
No,
Okay.
we're gonna change Roland to 6 months to 1 year, from 1 year to 6 months.
Yes.
Is there a second to approve that?
Second?
Okay. Any final discussion? Okay, all those in favor, please say aye.
Aye.
Opposed, the same? Okay, it looks like we have some renewals. I'll just quickly go through them. We have CDC for 1 year, Koenig Body and Equipment, I think we've dealt with them before, right? 1 year. Owens Excavating, 1 year. Ray O'Haron's Company, 2 years. SAC Construction, 2 years. VCNA Prairie, 2 years. And Vissy Sewer of Missouri, 1 year.
And actually, it was the recommendation on Koenig 1 year or 2 years.
2 years.
It should have been one.
No, it says one on.
Okay.
I'm sorry, what's the top?
Last recommendation and this year's recommendation.
Right, correct.
Yeah, it should have been one, so we need to. send
My
it
mistake,
back.
sorry.
Oh, I see the top one is.
Yeah,
That's the
Okay.
current one.
That should have been.
it should have been
Nope.
1 year,
Don't-
not 2.
And I'll move as per staff recommendations.
Is there a second?
Second.
Right. Discussion, questions, observations for your fellow commissioners or Ms. Clark? All right.
What's going on with Canaan anyway?
Well, they're very small.
Yeah, they're just above the threshold.
Just above, and they just increased by 2.
No, they just decreased. I think that's,
No,
Yeah,
Oh,
they increased.
Sorry,
I did
I'm
have
not
Right,
going
for 2, 'cause
the
they
right way.
increased, but we can
they
look at
increased
1.
by 2, but they lost a bunch of women and they lost their one
Yeah.
African American. It's not,
I think 1 year is
and they
sufficient.
lost their Native American. No, they didn't. They just went down a percent. This doesn't
I think we've certainly,
look very happy.
I don't, my memory's not great, but I think we've definitely requested additional information from them and, I mean, let them know that they're on our radar.
Hold on just a second, let me make sure that they, okay, so they did send information, I do remember now why I gave them 2 years. If you look in your packets, they did send information, they had sent a letter to Alex back in June of 2016, and she reattached the letter that she sent and all of her good faith efforts to try to get more minorities in there. So again, I think this was the one that we truly was leaving up to the commission to determine how long it was going to be for them.
And did you include this in that package? The letter?
I can print another copy of the letter if you guys would like that.
This is Koenig, right?
Mhm.
I don't remember.
You don't have to copy that, thank you though very
I
much.
think 1 year is plenty.
Okay. And we'll just tell them to continue
Yes,
with their good faith efforts.
Yep.
because they have lost ground, even numbers.
I wanted to comment that the ones, I see some improvement, which is great. SAC construction went up from 18 to 27%.
Yeah.
BCNA went up from 19 to 30%. I'm just looking at percent minority category for those of you guys.
And they've had 2
I'm
years,
impressed.
so that shows that something would happen
Even
even though, yeah,
But it works.
right.
No, I would say I'm satisfied with
Okay.
what the staff recommended in this, for all of these. I don't know. What do you think, Pete? Any comments?
I'm sorry, I didn't hear your last comment.
Oh, just that I was in agreement with the staff recommendations.
And we were excited to see some improvement in some of our vendors.
Yeah, I suspect there's one transcription error because I'm seeing the number of women at VCNA as 0 this year, which seems unlikely.
I can only go by what they submitted to me.
Yes. Okay.
Yeah, we'll give them a call.
I'm going to assume that it didn't go down.
79 to 0.
Yeah,
Yeah.
I thought that too when I put it down. I'm like,
Yeah, you-
but okay.
I mean, the number wasn't great in the first place, but it would be impressive if they went down to 0.
Okay, motion on the floor. I think we wrapped up discussion. So all those in favor, please say aye.
Aye.
Opposed, the same? Great, thank you guys. So that's EEO Workforce. Where would you like to go next, Lucilia, Ms. Clark?
I would like to talk a little bit about the HRO activity report,
Thank you.
and all of you have a copy of it. In Todd's discussion earlier, he mentioned that we were going to start keeping an eye on the caseload and the number of days that it takes to complete a complaint. And I just wanted to point out to you that 0817 has been, finding was issued on June the 15th, and it was a no probable cause finding. The complainant has 28 days from the date of receipt of the notification, which was the 21st of June, to appeal to the commission. Thus far, we have not heard anything from her in regards to her interest as it relates to appealing the ruling. So I do think it's important that we keep up with the cases and do them in as timely a fashion as possible. I did not include the cases that Todd referenced as the older cases, but he and I have managed to close a significant number of the cases, one of which resulted in a settlement.
Thank you.
And so that I'll make sure I include all of those cases next month on my report. And the other cases, the other 4 were no probable cause findings, and that's what he referenced. You may get an appeal request as it relates to those cases. And hopefully next month we'll be able to report to you that we've pretty much wrapped up everything that is outstanding at this point.
Great, thank you.
Okay. And the only other thing on my activity report was a contact that was pretty much an informal contact. Our landlord called on the phone to find out if in fact Urbana had protected class relating to conviction records and housing. She was very surprised to find out that we did, but she was also very cooperative in terms of her attitude about not using that as a basis to deny a person housing. So it was a really great conversation. So other than that, that's pretty much all in terms of complaints and contacts. So Monique, you want to go on the budget?
No budget costs to report this meeting.
Alrighty, thank you all. Are there any announcements anyone would like to make?
Well, we have our guest here.
Yes.
I would be remiss
Please.
not to introduce, and we have somebody on Skype too, so you're gonna have to move around, Ernestine. But we have in the house with us this evening, Mr. Donald Jackson, who is an esteemed employment law and labor law attorney over from Peoria, and his lovely, lovely wife, who served many years over at the city of Champaign, Ernestine Jackson, as the basically the HRO over there. They call him Community Relations Director, but she served many years over there and was a force to be reckoned with.
Indeed.
And since Champaign, you also work for the city of Bloomington. Are you still? Are you retired? Okay, but in the same capacity, a little different, maybe a little human resources too. And so Ernestine has a wealth of knowledge and information about human rights and civil rights, and so it is a pleasure to have both of you with us. Thank you. Thank you.
So the last
Brought her
meeting I
back.
had, Peter was on the commission at that time. Is that the same Peter?
That's the same Peter,
Yeah.
still hanging around.
Yeah, all right.
With glasses, but the same Peter.
Okay.
All right, well then, this meeting is officially adjourned, right? Or is it?
Adjourned or
Yeah, I think we probably want to leave the meeting in session
Okay.
for the presentation, just so we don't get into any goofiness about
Sure.
it.
we're in recess.
We're gonna be in recess for dinner.
Okay.
We're recessing, and then we'll.
All right, we're gonna take a recess, excuse me, let me
But you
correct
need,
that.
you need,
I will run down the hall and go to the soda machine here while you guys punch away.
I think you need a motion and a second to recess.
Okay, can we please have a motion for, to recess our meeting
I
tonight?
move we recess our meeting.
Second.
All right, all those in favor, please say aye.
Aye.
Opposed, the same, thank you, so we are in recess.
Peter,
All right, it's 6:18 on the June meeting of the HRC Commission. We're going to bring the meeting out of recess, and we are very grateful and excited that with Don Jackson, one of Illinois' great employment attorneys and a great asset to our commission several times in the past, is here tonight for a little bit of a refresher course and some training, we'll call it. So we're going to turn it over to you. Thank you very much for coming.
Well, thank you for the invitation. I appreciate it. I suspect that most of you know as much about this ordinance as I do. I had to do a refresher course in the last couple of days because it's really been a while since I've been down here in Urbana to do any work for the city. But at any rate, I'll talk a little bit about the ordinance itself, but really I think I'll focus mainly on the hearing process because I think that's what's certainly important to you. I think you all probably know that the city ordinance, chapter 12, creates the Human Rights Commission and Human Relations Commissions here. They're called different things wherever you go. In Peoria, it's the Human Rights Commission. And the state of Illinois is the Human Rights Commission. So this is the Human Relations Commission, consisting of 9 members that come from all across the community. And the way the ordinance is set up is that members of the commission can be nominated for a position to the mayor from any organization, the NAACP, church groups or other organizations who have an interest in the city ordinance itself and what it stands for, which is the eradication of discrimination anywhere in the city. I have to say that you probably have the most comprehensive ordinance that I've encountered in the state, with the exception and probably parallel to Bloomington's ordinance. The city of Peoria, as compared to this, is nothing but a piece of paper. So something we have to work on is the NAACP over there. But this is a very comprehensive ordinance, and the commissioners serve a term of 3 years, which are staggered. And one of the significant parts of that in the ordinance is that if you, at the time that your term expires on June 30th, in the staggered year, if you're serving on a panel of a hearing, then you continue to serve notwithstanding the fact that your term expired, and you're called a holdover commissioner in the ordinance, which I thought was unique. And so to that extent, it's really a super ordinance. And of course, you all know what the duties are, so I won't belabor that point, but it really is to work with groups throughout the city to make sure that discrimination does not get a foothold in Urbana, and certainly if it does, it's eradicated from the city. The ordinance is, the mission, of course, is, as I've said before, is to make sure that all groups in the city have an equal opportunity to participate in all of the city's functions and the government itself, regardless of the kind of group that you're in, whether you're a church group or a Muslim group or gay and lesbian or transgender or even labor organizations. The point is to work with the commission to accomplish the goal and the mission, which is to, again, eradicate discrimination based on what the ordinance has to say. I do want to repeat what the ordinance says about the type of discrimination that, and this is what I think is so unique about your ordinance, it is the intent of the city of Urbana in adopting this article to secure an end in the city to discrimination, including but not limited to discrimination by virtue of race, color, creed, class, national origin, religion, sex, age, marital status, physical and mental disability, personal appearance. That's a unique one there. The others that I've mentioned so far are pretty much standard throughout the industry, whether it's the Title VII or whether it's the human rights, the HRA, or even other ordinances throughout in other cities. But moving on, sexual preference, family responsibilities, matriculation is a new one. I've not heard of that one before. Political affiliation, prior arrest or conviction record, or source of income, or any other discrimination based upon categorizing or classifying a person rather than evaluating a person's unique abilities and qualifications. Now contrast that with the Human Rights Act itself in the state of Illinois. You'll see you've got an expanded scope versus the state law itself, which encompasses mainly race, color, religion, sex, national origin, ancestry, age, order of protection status, marital status, physical or mental disability, military status, sexual orientation, real estate transaction, credit, and public accommodations. So your ordinance is much more expanded in terms of the scope of discrimination you're trying to eliminate. And I think that's commendable on many levels.
Does the state law not have one of those clauses like for any other category?
Well, they have other categories that, financial transactions, real estate transactions, that sort of thing. But they
But
really
they
don't,
don't
no,
have
they
that
don't
sort of
have any other
overarching-
category. Not in the state ordinance, not in the Human Rights Act ordinance, no. And the other thing that makes you different, and most cities makes it different, is the fact that the state says 15, you have to be an employer covered by the act, you have to have 15 or more employees over a certain period of time, 20 weeks within the year just before the act of discrimination. And you don't have that, and there's a reason for that, and a very compelling reason, and that is that an employer, if you didn't have that, an employer who has one employee, for example, could say to someone who applied to his or her business, I'm not going to hire you because you're black, or I'm not going to hire you because you're handicapped, or I'm not going to hire you because you're transgender, and get away with it. But your ordinance has, in its description of an employer, it doesn't limit it to 15 or more, or some number or more. It says discrimination by any employer with one employee. I think there's only one exception in your ordinance, and it doesn't come to me at this point in time. But I think that's also true of most cities. I think Bloomington had the same thing, that it was employers didn't have to have a certain number of employees before the act covered them. So, and that covers a gap that a lot of employers throughout the state in various cities that may take advantage of. If they don't have an ordinance in the city to prevent that, then they could openly discriminate as long as they had 14 or less employees, which I think is a horrible condition in the state. And there's nothing you can do about it. I know that that came up a couple of times in the city of Peoria, and it was useless to refer people on to the state when those employers discriminated openly. Because there wasn't anything the state could do about it. So it's commendable that the ordinances have that. Now, there are some, as you know, some categories that are exempted from, even if they've got, someone claims that they have discriminated against them, if they have a bona fide occupational qualification, a seniority list, or you have to, you have to be, if somebody wanted to be hired at a particular enterprise and they needed a carpenter, and if you weren't a carpenter, of course, they could say, no, I can't accept you, and you can't claim race or sex or anything in circumstances like that because you need the qualification in order to be considered for employment within an establishment like that. Some of the other things that I found in the ordinance that I think are worth repeating, the personal appearance one, as I said, was kind of unique. It has an exclusion there as well. It shall not relate, however, to the requirement of cleanliness. And I found that to be kind of unique because I guess you could be discriminated against if you came in and didn't smell right when you were interviewing for the job. I'm not so sure that's a bona fide qualification, quite frankly, or exclusion, but it's an interesting exclusion at any rate. And of course, the other thing is sexual harassment. I think the ordinance is super descriptive in terms of what you cannot do as an employer when it comes to sexual harassment. And of course, the description in there sort of parallels the Title VII as well as the Human Rights Act for the state of Illinois in terms of making sex a condition of employment or even a condition of retaining your employment in many respects. And so that one I think is pretty much parallel to other statutes and protections against harassment or against harassment based on sex. Other than that, I think the ordinance itself is pretty unique. I think since I last did work for the city, there's been an addition to the ordinance, and that is in terms of the hearing process. You've added a condition, an initial hearing condition, that was not in the ordinance when I practiced down here. And that's a good thing, because I think it gets, even though the hearing officer has to be appointed by the chairman of the commission, prior to that, it does eliminate some wasted time in terms of requests for subpoenas and motions and that sort of thing. You get them out of the way within, the first 30 days, I think. And that's a good inclusion in the ordinance, I think. But after that, I think it pretty much parallels everything that was required at the time that I was last down here in terms of the time limits. I think you all know that there's one other change. I think when I last tried, when we did the Carl Clinic case, the commissioners sat around the table with me and were able to make inquiry, and this ordinance now requires that it be done through the hearing officer. You have to ask the hearing officer to ask questions. But procedurally, most of everything else is pretty much the same. The hearing process initially starts with someone filing a complaint, and they can file it with the city attorney's office, or they can file it with the commission, or they can file it with, you got, Todd's position is the human rights officer, is that?
Well, actually, his current position is Human Resources Director.
Okay.
But the Human Rights or Human Relations Officer.
Right.
Mm-hmm.
So that's a different position then? Mm-hmm. Okay. So it can be filed with them, and of course then the initial notices are generally sent out by that office, and the process begins there with the complaint. The respondent, that's the person that's been charged, has a certain amount of time to respond to the complaint, and I guess respond with a motion to dismiss, which I think will take place during that initial process. Any motions that have to be heard from the beginning. And then once the complaint is that issue, then the process of discovery takes place. Both the commission and the hearing officer have the right to grant permission for both sides to conduct discovery. And I don't recall anyone ever taking any depositions in any of the two cases that I had, but generally interrogatories, requests to produce documents, that sort of thing. And that's controlled by the commission through the hearing officer, because that can get out of hand from some time, when you get flooded with, say, 50 interrogatory questions, some of them which may be relevant and some are not relevant. Then it's up to the hearing officer and the commission to control that process, to streamline it, to make sure that the parties stay on issue and don't burden either side with too much garbage discovery. And really, the same thing holds true with subpoenas. The commission and the hearing officer can control the number of subpoenas that are issued, and really the individuals who are subpoenaed. I think there's a process in this ordinance that allows you to question the purpose of a subpoena, why what the witness that you want subpoenaed can bring to the table. And of course, if it's not relevant or tangentially relevant, the commission has the authority to deny. The commission and the hearing officer have the authority to deny the request for a subpoena for a particular witness. And that would hold true of documents as well, that may be requested to be subpoenaed through the process. The complaint, of course, is tested from the beginning, whether or not there are two questions that are asked from the very get-go. Does the commission have jurisdiction over the case? And the second question is whether or not the complaint really states a cause of action under the ordinance. In many cases, the complaint could be dismissed at that point in time, has not had, on the grounds that the commission doesn't have jurisdiction, and secondly, that the complaint doesn't state a cause of action under the ordinance. At that point in time, the complainant would have an opportunity to appeal that decision through the commission itself, although only one commissioner, along with two other persons, it doesn't identify who they are or where they come from, can hear that appeal, and if they conclude the same thing, that the commission doesn't have the authority or doesn't have jurisdiction or the complaint doesn't state a cause of action, that's where it ends. At that point in time, the complainant could certainly appeal to the judicial system, I suppose, but if you get denied twice, you would think that that would end the circumstances, although some people are very litigious and would probably take it on anyway. But if it does pass muster at the initial hearing, then of course, after discovery, the deadlines are well set out here in the ordinance in terms of when everything has to be done. The initial hearing has to be done within 30 days, but not more than 60 days. Well, first of all, let me back up a little bit. The complaint itself has to be filed within a certain period of time. And the outside deadline is no more than a year. It's got two different 30 days or 90 days, within 90 days, 45 days, 90 days after the incident or after you discover the incident, and then after that, but no more than 1 year from the date of the incident. So some pretty definite deadlines that have to be met by a complainant before he or she can proceed with the complaint. And that's more than enough time for someone to decide that he or she has been discriminated against, or at least they believe they've been discriminated against, in order to file their complaint with the city. After the initial hearing, of course, there's deadlines throughout the whole process, mostly controlled by the hearing officer. And that's that's different than when I last tried it, because as I recall, the commission itself, or the commissioners who sat with me on those hearings, were pretty much in control and through the hearing officer. But here the hearing officer has much more control over the process than the commissioners. And my recollection was then that all the commissioners were invited to serve, but they had to be at all the hearings, or they could not deliberate in the process. And I guess that's the same in this ordinance as I read it today as well. So, and of course, the hearing officer's role is, as it's always been, to make sure that the evidence that comes in into the record is good evidence. Hearsay is excluded, and the rules of evidence apply to the hearings, although in hearings of this nature, they're sometimes relaxed because, first of all, it's not a jury process, and the advancement of evidence into the record in a jury trial is much more strict than it is, say, in a bench trial or in a hearing of this nature. And basically because, jurors don't have the skills to know what evidence is admissible, what evidence is not, and so they have to rely on the judge and the attorneys, opposing attorneys, to control that. And the judge, of course, is the ultimate one that controls it, because he has the ultimate right to rule on evidence that come in. They're not always right, but at least that's their function. Well, to some extent, that's the function of the hearing officer as well, to make sure that the evidence is good evidence. And, but as I say, hearings of this nature are a little bit more relaxed in terms of evidence. You want to give both parties an opportunity to get their case in. And sometimes, well, the city attorney is the one who represents the complainant in the case. And most generally, the respondent is going to have an attorney. If the respondent does not, then there's some deference given to them simply because, they're not licensed lawyers. So hearing officers generally will give some deference to those, but they won't let them run wild with respect to the kind of evidence that they bring to the hearing. The hearing officer's role is to rule on all objections that are made during the course of the hearing, and eventually bring it to a close. Procedurally, you generally have the complainant goes first, respondent second, then there's rebuttal testimony. That means once the complainant hears respondent's case, he or she gets to rebut that evidence, and then, of course, respondent gets to rebut the evidence that the complainant just rebutted. So, but that's pretty much, in some cases they go, hearings of this before commissions like this, they'll go sur rebuttal and sur rebuttal, but that's extending it, in my judgment, a little bit too far. If you can't get the evidence in on direct examination or cross-examination or rebuttal or sur rebuttal, that's enough. Whatever you could possibly get in should be in by that time. But again, that's up to the hearing officer to control, and your ordinance only allows, I think, for rebuttal and sur rebuttal, and that's the extent of it.
And,
yeah, go ahead.
One thing that I learned in that first hearing we did was some of the reason that you can let more of the evidence in or be more relaxed about it is, unlike a jury where they just say guilty, not guilty, or we find for the plaintiff, we find the defendant, we actually produced a whole, finding, a whole conclusion with conclusions of law and conclusions of fact and,
right,
and all that. So we've got a record of what we decided on, and it's you don't have to kind of make sure that nothing sneaks in beforehand.
Right, exactly, and I was getting to that. Getting to that point. Once the hearing is closed, and of course these are all the. There's a transcript of all the hearings, and it then becomes the job of the hearing officer to review all that evidence and to cull it down, to reduce it to factual findings, conclusions of law. And when we did the Carl Clinic claim, I think we even made recommendations as to damages, but now the hearing officer just his or her responsibility or factual findings and conclusions of law based on the authority that comes from the act itself, from the ordinance. The discussion about damages takes place at another time, and that's more the responsibility of the commissioners than it is the hearing officer. He or she will actually reduce it to writing, but it's really up to the commission to make the decision about assuming they find liability, about whether there's going to be damage, and if so, how much the complainant would be entitled to. So that's a difference, because my role at the last hearing was to do all of that and make recommendations to the commission. But ultimately, it's the commission's decision. Go ahead.
Can I interrupt, Peter? We're interrupting just momentarily. We have with us our mayor, Diane Marlin, and I wanted to make sure that she got to meet all of you. These are our commissioners.
How you doing?
Don Jackson.
Don Jackson. My pleasure. My wife Ernestine.
I know some of you, yeah.
You know, okay, you know Carol and Lisa. You know all. Mm-hmm.
Katie Thomas.
Daniel?
And Peter Resnick.
Well, hey.
And Diane was here in the building for another meeting, and I invited her just to stop in to introduce her. She's been most busy. I think she's been here 12 hours in another 10 minutes.
Wow.
So I don't want to, didn't want her to have to stay unduly, but I definitely wanted everybody to be able to meet her.
Just wanted to stop
Good to
in,
meet
say
you.
hello, thank
Yeah.
you for your service, and I look forward to working with you. I just came from a neighborhood safety task force downstairs.
Oh,
meeting,
okay.
so-
Well, thank you for stopping by. I
Thank
really
you.
appreciate it.
All right, bye-bye.
But in addition, during the course of the hearing, in addition to the hearing officer posing questions to the witnesses, as I mentioned before, the commissioners who are in attendance also have the right to do that. The only difference between this ordinance now and the way it used to be is that the commissioners didn't have to get the permission of the hearing officer to ask questions, but now they ask them through the hearing officer, who I'm sure would not ever refuse to ask the commissioners questions of a witness. So, but once the testimony is completed, it's the responsibility of the hearing officer to make the recommendations to the commissioners in terms of whether, first of all, he finds liability, and then to support it with the factual findings as well as the conclusions of law, and to document it in specifically to the ordinance in terms of the violation itself or violations. And then the commission either adopts those findings and recommendations, in which case the hearing officer then prepares a final order along with damages, and that order is disseminated to the lawyers, the city attorney, and the counsel for the respondent. They have a certain period of time to file objections. I think it's 30 or 45 days. The ordinance is very clear on these time limits, so forgive me if I can't remember them all, but no one goes on the bench without looking at this ordinance every day, every time you're sitting up there. But at any rate, if the commission then can hear the objections and doesn't change its mind, that becomes a final order. It's reduced to a final order. And the parties, if they still believe they have either proved their case or the defendant has, respondent has successfly defended the charges, then their next step is in the judicial, where they can appeal to, but there's no rehearing under the ordinance. It's final once the commission makes its decision. And that's pretty much the process. It's nice and simple and it's easy, but it's also intended to be a fact-finding process. The complaint has to be proved by a preponderance of the evidence, which basically means it's more likely than not that the infraction occurred, and that requires just common sense. Doesn't mean that you have to be 100% sure, but at least common sense tells you, I feel like this did happen because. The other two standards don't apply. Beyond a reasonable doubt, of course, is a criminal level of proof, and there's one other one. Let's see, what is it? But very rarely used in any kind of litigation I've ever been in. What am I missing one?
I thought just confused, so.
Clear and convincing evidence. That's a standard that's rarely used in any kind of judicial process that I've ever been involved in. So preponderance of the evidence is really the lowest of the three standards at any rate. But it's as I say, more likely that it happened than not. And that's the kind of evaluation you have to give to the evidence. That was short and sweet. Any questions? Wow, did I do that good a job, Peter?
I think so.
Just fine. Although I will say the hearing rules are under our control to change. Where the ordinance, we'd have to get the city council on board.
Exactly. Yeah.
We could officially change the hearing rules if we decided that something wasn't working. So if you have recommendations to us,
Oops, he froze?
Yeah. There you go. Say it again.
Okay, say it
You
again,
froze
you
up.
froze.
sorry, the internet's did a funny thing.
Yeah.
So the hearing rules are under our control, whereas the ordinance is not, right? The city council has to make changes to the ordinance, where the hearing rules, we can actually vote changes to them. So I guess one question is whether you have anything in those hearing rules that looks funky that you think we should be changing, although we haven't tried out these new hearing rules yet, so we have little experience.
Yeah, I noticed that this was, in fact, the city just told me that this was a sort of a recommended document that was sent to me. So I got the impression that you were in the process of looking at this and trying to tweak it so that it better serves the purpose of the commission. But at this point,
I don't remember how many of us were on when we introduced this, but it was because in part of the Carl case and the ones after,
Comcast case.
we've
And those
taken
were the two
so
cases.
long that we thought, okay, we tried this, especially for employment cases, we would try this where the hearing officer really did the bulk of the work. And we still haven't had a chance to try out these hearing rules at a hearing yet. So, this is still sort of in the testing it out phase.
Yeah.
And the goal, Peter, is with these new hearing rules, is for you to appoint, the chair to appoint a hearing officer that would then hear all of the evidence, right? Not the commissioners.
right.
Right.
Mhm.
It says
Right,
we
so
could
we
be
wouldn't
there
have
if
to
we
be
wanted.
present for all of it. The hearing officer would do the work, listening to the case, and then submitting the suggested findings of fact and such to us. Whereas you, when we did it under the old rules, and those rules still exist, we can still use them. But back then, we all got together with you, sort of decided what the case would be, and then wrote it up for us,
Right.
and
Exactly.
then voted it out. So
Right.
it's a different procedure, but we haven't tried it yet.
And as we were mentioning during the break, some of the people that served then remembered that you had to be, as a commissioner, at every one of the hearings. Otherwise, you were not allowed to be part of the discussion about whether or not there was liability, and if so, what damages might be. So
Right.
this makes that much easier. Commissioners can actually miss a hearing or two, and Carl was a good example of that because it went on so long. They can miss and still participate in the discussion based on the recommended order and decision by the hearing officer.
Well, one of the reasons it went on so long, it was a long case to begin with, but then to schedule it so that all of the commissioners could be there
Right.
with our day jobs and do it in the evenings, it was just...
That was
it was
difficult.
awful.
Yeah, that was a difficult process, no question about it.
This should really speed things up.
Yeah, I think so. Yeah. The other thing is that this allows the chairman of the commission to obtain the services of a hearing officer and have him or her under contract, so to speak, over a number of cases instead of just picking a new hearing officer each case as well. So that's a good provision, I think. Someone to get used to the ordinance itself and applying it in a hearing. So, any questions? So
That's
you
a
guys
broader
are really-
question.
Go ahead.
Unrelated to our ordinance,
Mhm.
but while only anecdotally, I'm hearing a lot of instances of discrimination, and the justification is, well, the person in the White House. Are you? I just want to ask you a general question, professional. Are you concerned about the mood of the country right now? Are you seeing an uptick in anything that should be on our radar, or just kind of wait and see what happens, or?
Well, I don't know that it's ever diminished, quite frankly.
Okay, or yeah, I shouldn't have
From
assumed.
President Obama. You
True,
would-
very good. I should
You
not
would
have.
think that,
Just more visible, maybe.
yeah, well, yeah, it's up front, and in
All right.
your face now, no question about that. And it may get worse, there's no question about it. They may, I think employers may get to a point where they think that they've got a friend in the White House. I mean, he's talking about changing, some of the civil rights statutes and
Absolutely.
that sort of thing. So it could get better before we know it. So it's something to keep watch. But as long as we've got these local ordinances like this, it's going to help a lot to keep to stem that tide, I think. Yeah.
I haven't read your ordinance, but is there an initiation clause where the commission can initiate a charge?
Yes, commissioners can also.
So that would cover what you're talking about. You hear this store always does, then you have the right to, as a commission, to initiate a charge.
That's a good point.
Thank you.
Right, this ordinance does do that as well. Anyone can initiate the charge. That's the beauty of the ordinance. If someone sees something happening and they know it happened, the commission can investigate it, so.
Sorry, Fran. I think Fran had a question.
Yeah.
I was,
sorry, go ahead.
I was wondering about enforcement of the findings or the rulings of these hearings. Are they enforceable in the same way in a court of law?
Yes, that becomes the city attorney's responsibility to enforce the findings of the commissions and to collect the money or change the practice within a company, that sort of thing. It's up to the city attorney then to take it into the court system and enforce it.
Okay.
Assuming that the respondent isn't bright enough to say, okay, it should end here, and do what he or she is supposed to do.
Right.
But if not, I mean, if you get some hard-nosed business owners that, well, I'm not gonna listen to what the city says. He or she does that at their peril. She just finished the case over there against what, YWCA?
And Wilmington.
Yeah,
And they appealed it to the circuit court,
and to the Supreme Court.
and the city won. Then they appealed to the appellate court, and the city won. I'm out of the loop now, so I haven't heard, but my understanding is it stopped at the appellate court. All that meant is that the Y, being an agency that depends on people's money, ends up paying a lot of money because the attorney fees keep going. The person that filed the complaint, that money stopped as soon as he filed the complaint. But the attorney kept rolling. So you
But
get
the interest on the money that was
Right.
awarded the complainant also keeps rolling.
Yeah.
So the debt just gets larger for those who to try to challenge the decision of the commission, in this case, the commission over in Bloomington. And it's an interesting case because a case that could have been settled for
$3,000.
ended up, I think the last figure
The
on the
attorney's fees were
were.
$68,000.
Oh, my goodness.
And,
You know-
and he was owed $60,000. So
And it was what type of case?
it was a.
There's actually a very good
race and
point
sex.
there.
Okay.
When we have a case, it's not the complainant versus
Right.
the respondent. right? It's not, Joe Smith
It's
versus
the city
Mary
of
Jones.
Urbana.
It's City of Urbana versus Mary Jones.
Exactly.
Like in criminal
Right.
case.
That's nice.
So that, complainant is not responsible for attorney's fees or anything like that.
Right. And in this case, the respondent in that case in Bloomington was the YWCA, and their attorney's fees just kept rolling because the attorney.
Well, the attorney for the complainant kept rolling,
Yeah. Well, yeah, I mean,
because he got an attorney, so.
So not the city of
Oh, and pro
Bloomington.
se people,
yeah,
they'll go forever sometimes,
yeah, but.
if they do their own.
Yeah, if they do their own. But-
That's one case I knew somebody like that. It was always going all the way to the appellate court. in the
Yeah.
state.
Yeah, there was a
Two or
guy
three
that went
cases
to
at a
law
time.
school with me that lost his license, but he became a pro se litigant over everything, and the appellate court in the Seventh Circuit finally said enough. The courthouse is closed to you from now on, and they barred him from
It takes a
filing
lot.
anything
That
else
takes
after
a
a
lot,
while.
yes, it does.
It takes a long time for them to come to a decision like that.
Well,
It
Sure,
certainly
well,
is possible.
yeah.
So,
Any other questions, Pete?
I will take a look at this, and if I got any recommendations, I'll get in touch with Cecilia or Todd and let them know. But I didn't look at it from that point of view,
Okay.
so, but I will do that. Yeah.
And I think Todd did a pretty good job of preparing them for us.
Yeah, I'm surprised to
It's
hear
always
he's
good to have
back.
another set of eyes.
Yeah. Well, I enjoyed working with him. I was sorry to see him go to Los Angeles for
It was just a
a very short
hiatus.
period. Yeah.
Yeah.
Give us a winter
Here's one
program.
I
Sabbatical.
vacation.
Well, the other one, I was surprised when I heard from Cecilia and found out she was back in the city. I said, wow.
They love us.
Yeah.
They don't want to leave
Can't
us.
stay away.
Well, again, we want to say thank you so much
Hey,
Thank
my
you so
pleasure.
much.
Yeah,
Thank
not
for
a
your
problem.
time and
That was
expertise. We
wonderful.
hope you have safe travels back. You going back to Peoria tonight?
Oh, yeah, we're gonna stop and have dinner
Great,
someplace. and
great.
then
Well, we hope you have
we'll go
a nice evening and safe travels, and thank you again.
back. Yeah,
Absolutely.
well, I hope the traffic going back
Yeah. Let up.
is lit up by now, but
Is there a
it was a
problem?
horrific
Yes, sir.
accident, horrific.
Big accident.
Accident by
unfortunately.
Leroy.
Yeah.
So, any final announcements? If not, we'll be back in July at our normal second Wednesday.
Yes.
Oh, can I ask, will we do a
We have-
summer vacation?
We have done that in the past.
I thought that was August.
It was generally August,
It is
but
August?
I don't think we did it last.
we did not.
Alex was nonstop.
Not Alex.
Steve Gregory was.
So we can decide that at the next meeting.
It was
but-
our break.
But have that on your radar, everybody, if you
Just
want to just.
saying.
No, in the past, it's been historically, we
Monique's nodding her head.
At
Oh,
least-
I
yeah.
take my son to school, so
And I
that would be
won't
at
perfect.
least once a month, at least once a year, we
And you
take
won't.
1 month off. And usually it's August. So,
Carol said she would be gone, so.
okay. We'll confirm it next meeting, but until then, this meeting is adjourned. Thank you all for everyone for making this night possible. Thanks. See you, Pete. Safe travels.
Thank you.
Thank
Good to see you
you.
again, Pete.
Next month.
Yeah.